Good afternoon, everybody. We're going to be giving it a minute for everybody to get into the session. And this session is going to be recorded. We'll have Spanish interpreting, also ASL interpreter. And if you need to select the language of your preference, look at the bottom of your screen, and then you'll see the icon of the earth, and then click on it and click on the language of your preference. It could be English or Spanish. Buenas tardes a todos. Vamos a comenzar en un momento. Esta sesión será grabada. Tiene interpretación simultánea al español. Tenemos intérprete de lenguaje de señas en inglés. Y si necesita escoger el idioma de su preferencia, vaya hasta abajo de su pantalla, haga clic en el icono de la Tierra, del mundo, y ahí podrá escoger el idioma de su preferencia. Puede escuchar esta conferencia en inglés y en español. Vamos a comenzar en un minuto más.
Mariana, will you tell me when to begin or?
Yep, you're good to go now.
Okay, great. Hi, everybody. My name is Felix Sanchez, immigration lawyer, and I want to thank everybody for being here and for giving us the opportunity to reach out to you and for us to be able to teach a little bit about immigration law. I'm here with my colleague, Antonio Estrada, and I, myself, am an immigration lawyer, duly licensed by the California State Bar, actually a legal specialist in immigration and nationality law. And today, Union Law Group is my firm, and we started 15 years ago. We have offices on both sides of the border in Tijuana and in San Diego. I have clients, fortunately, all over the world, not just here in San Diego and Tijuana. And we deal exclusively with immigration law, right? So I'm an immigration certified specialist, and we deal with all sorts of immigration related issues, from family petitions to humanitarian visas like VAWA, Violence Against Women Act, to business visas and everything in between, right? And later on, Antonio will talk a little bit about your rights in the United States, whether you have papers or not, right? And I'll let him do his own introduction. So Antonio, do you want to introduce yourself?
Hi, good afternoon. Yes, my name's Antonio. I'm also an attorney here at Union Law Group. I've been with the firm for a little over a year, but I've been involved in immigration a little over 3 years now. So yeah, I'm very, very excited to be here.
Excellent. Thank you, Antonio. And so why don't we get started on actually, I think, Antonio, you're going to begin, right? So you're going to get started on removal defense. So Antonio's going to talk about what your rights are in the United States, whether you're an immigrant, whether you have papers, or anything anything in between. So Antonio, I'll let you get started.
Okay, perfect. Thank you, Felix. Okay, so before I begin talking about immigration court and removal defense and all this stuff, please rest assured that ICE is not looking for every single undocumented immigrant and deporting every single undocumented immigrant. That's not the purpose of this presentation. The purpose of this presentation is for us as a community to know your rights. So, whether it's immigration, criminal, contracts, we all need to know our rights, and it just so happens that immigration is one of them. So please think of that as I'm presenting, that this is not to scare you, but simply to inform you of your rights. So what is removal defense? What is EOIR? EOIR stands for Executive Office of Immigration Review. It's a legal way of saying immigration court, and as we attorneys call it, removal defense. So just to give you a look or a little taste of what immigration court looks like, Immigration court will look in, it depends on 3 stages. So somebody will be detained by ICE and then they'll get placed in immigration court. In immigration court, we divide the process into 3 stages, which are the charges. And in immigration, it mostly has to do with deportability, removability, somebody being establishing whether they can be removed or not. Then after that, if that so happens, to get past that first stage, we move on to the second stage, which are applications for relief. What are some applications for relief that we could, as an example, asylum, withholding of removal, adjustments, voluntary departure, things like that. So we file the applications and then we proceed with the trial, or as we call it in immigration, a merits hearing, which is essentially just listening to evidence, direct examination, cross-examination, and figuring it out whether the applicant qualifies for whatever relief the attorney presented. Now, obviously, we want to stay away from immigration court. And how do we stay away from immigration court? Well, by exercising our rights, which brings us to what rights do we have? I'm sure with the past administration, we all heard this saying of, oh, someone here without status doesn't have any rights. Well, I'm here to tell you that that's not true. Yes, a non-citizen doesn't have as many rights as a citizen would, but that does not mean that a non-citizen doesn't have rights. That is a complete lie. The Supreme Court and the Ninth Circuit have said that some rights expand to citizens and non-citizens alike. What is one clear example of that? The first one is called the Fourth Amendment. I'm sure everybody's heard of this amendment, whether in BTV or in high school, etc. But the Fourth Amendment does apply to citizens and non-citizens alike. What is the Fourth Amendment? Well, this is the actual language of the Fourth Amendment. The Fourth Amendment to the United States Constitution prevents the government from unreasonable searches and seizures against someone. What does that mean in plain English? It means that cops, or in our context, immigration, cannot search you or your property without a warrant. Again, I've been doing this for 3 years. Never have I seen immigration have a valid warrant. What do they usually have? They usually have this document called it's called an I-200. It's essentially a warrant by ICE, which in our context has no legal bearing. What do I mean by that? If they have an I-200 and they present it to you, they cannot come into your home, they cannot search your car, they cannot search the trunk of your car, and they cannot search your belongings. What is one way that they try to overcome that? Consent. What does that mean? It means that they'll try to coerce you into consenting. They'll try to trick you into consenting. They'll say, if you don't open the door and let me search your house, it'll be worse for you. They'll say, if you don't let me search your trunk, it'll be worse for you. If you don't cooperate with me, it'll be worse for you. Exercise your rights. Exercise your Fourth Amendment right. Tell them, no, I don't care what you say. You do not have my consent nor my permission to come into my house, to search my car, to search me, to stop me. Okay, so that's very, very important. The exception is if you cave, if you actually believe their lies and say, yes, you can search my home, you can search my car, well then, if you consent, then they can search your home. So again, and they can search your belongings and your property, etc. So again, please, 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 very important, Fourth Amendment right. Remember, you do have that right. Another right that we have, that citizens and non-citizens have, is called the Fifth Amendment. What is the Fifth Amendment? Again, here's the text. But to simplify what it means, it essentially means that you have a right to remain silent. A right to remain silent, meaning do not answer questions. What are some common questions that ICE asks when they stop someone? When they stop someone, they usually ask them where they're from. Again, in the context of immigration, that is an incriminating question. You have the right to say, nope, I don't answer any questions. You also can say, I don't answer any questions and I want to speak to my attorney. And you call me or you call an attorney right away to exercise your rights, but again, make it clear. I am not going to answer any questions. I want to speak to my attorney. If they try to court again, and this comes back also to the Fourth Amendment, the only way they can make you speak is if you consent to speak. So again, remember, please exercise your rights. Exercise your Fourth Amendment rights, saying, no, you cannot search me, you cannot search my belongings, and our Fifth Amendment right to not say any question, answer any question whatsoever. Now to the next slide. Say you're stopped by an officer. An officer is going to ask you to ID yourself. Again, you respectfully decline. But if they keep insisting, well then, there's some IDs or some documents that I recommend you do have on you and some documents that you do not have on your personal belongings. I basically do not recommend that you carry any belongings, any IDs that shows that you're a foreign national. What do I mean by a foreign national? Showing that you're Mexican, that you're Filipino. Any document from your country of origin will show that you're a foreign national. What do I mean by that? A birth certificate, say a Mexican birth certificate, a foreign birth certificate. In the context of Mexico, an ID that allows you to vote, that's a Mexican voting ID. A Mexican driver's license, a consular ID card, a passport. All of these documents, leave them at home. Do not carry them with you. I know the fear will be, well, what document do I use to identify myself? If you do have here in California, we have this thing called AB 60, where you're allowed to get a driver's license. So if you have that, carry that and only that. If you have nothing and don't want to get a driver's license, well, I would instead recommend, if you have a choice not to carry any ID, a foreign national ID versus no ID, do not carry any IDs. So again, any identifying document that identifies you as a foreigner, a foreign national, please leave all those documents at home. So what I just talked about are what's called immigration court. Anything related in immigration court is defensive applications, whether you're in immigration court in detained immigration court at the immigration detention facility or a non-detained but still immigration court as in downtown or your local immigration court, those are all defensive applications. So we always want to avoid defensive applications because the probability of success drops when you're at immigration court. The reason for that is that you deal with an immigration judge, somebody who has a law degree, somebody who is a judge, somebody who has years and years of experience and knows the law back and forth. That's more difficult because it doesn't give us a lot of wiggle room to argue. With that said, we rather do affirmative applications. What are affirmative applications? Affirmative applications are those filed with USCIS, United States Citizenship and Immigration Services, and you're not in immigration court. So with that said, we always want to be in the affirmative applications because our probability of success is much higher. We deal with a trained USCIS officer who is not an attorney per se. So when we are not in immigration court, we have much more wiggle room to do a legal argument, to advocate. But yes, we definitely do want to be in the affirmative applications rather than in defensive applications. And with that said, Felix is going to speak to you about the affirmative applications.
Thank you, Antonio. I appreciate it. And yes, following up what Antonio just said, the best way to defend against a deportation or removal is to get your residency or your citizenship, right? Once you're a citizen, that's it. They cannot deport you. So if you have a solution, our recommendation is always look for that solution before you get into trouble. So if you do get into trouble, please reach out to Antonio or any attorney. It's really, really important that you do not self-represent in court. But before you even have that issue, please look for some solution. You owe it to yourself, you owe it to your family. Great. So what I'm going to talk about is how to immigrate. And usually that starts with some sort of petition. Now we can do different petitions from, let's say, an employer, right? An employer can petition you. You can also have a self-petition, such as a Violence Against Women Act, or through something like a U visa for victims of violence. What I'm going to talk about first is what's called a family petition. And this is usually in our practice what we see the most. And you pretty much know, maybe somebody in your community you've heard of somebody going through the immigration process. And usually this is where we begin. What is a family petition? This is where somebody files a petition for you for your residency. Normally that could be a US citizen spouse, that could be a US citizen parent, it could be a US citizen sibling, brother or sister. And these are the different categories, right? So on the left side, you see if you have a petition through a US citizen, you're going to be in one of these categories, IR1, IR2, IR5, or down at the bottom, F1, F3, or F4. Now, if you're having a petition filed through a brother or through a permanent resident, what petitions are we looking at? F2A, F2B. Now, if you notice, a permanent resident can only file petitions for who? For a spouse and for children, right? Those children can be under 21 or they can be over 21. But if they're over 21 or under 21, they have to be single, right? So many of us have heard of somebody saying, hey, I can't get married because my father petitioned me, right? That's the reason is because the father is a resident, has not become a US citizen yet. Now, can a US citizen parent petition a married son or daughter? Yeah, an F3, married children, 21 years or older, right? What if it's single? F1, unmarried children, 21 years or older. Can a US citizen petition a sibling? Yes. Can a resident petition a sibling? No, right? There is no equivalent. So this is where we usually begin, a petition. So the very first thing is, who can file a petition for you? Can I have more than one petition? Absolutely. Now, if I'm going to have a petition filed, I want to be in the IR category, right? A spouse, child under 21 years of age, or a parent of a United States citizen. So many of my clients that are in the United States, maybe without status, came in 20 years ago, 25 years ago, had children in the United States, and many times they ask me, can my child petition me? I heard that parents cannot immigrate through children. That is half true. A child can petition a parent. Later on, we will talk about waivers, or in Spanish, perdones, and that is a little bit different. But just for now, rest assured that a child, United States citizen child, can definitely petition a parent. Now, why do we want to be in the IR category? I just mentioned it. We want to be in the IR category because the F categories are what we call preferences. And preferences, you have to wait in line for a visa to be available. And if you can actually go back one slide, this is really important. So an IR category, there's visas available immediately. So again, if I'm a US citizen and I'm filing a petition for my parents, there's a visa available today, an immigrant visa. Now, if they can immigrate, that's a second point, and we'll talk about it in a minute. But the point is that we have a visa available the day that the petition is filed or the day that the petition is approved. With F categories, everything from F1, F3, F4s, F2As, and F2Bs, we have to wait in line. We have to wait all the people that filed their petition before we did. Now, for many people in my practice, that means they're from Mexico, and currently a petition, let's say an F4 petition, which is a sibling petition, is approximately 25-year wait, right? Now, who wants to wait 25 years for the residency? Nobody does. So what happens is that, again, if we can be in the IR category, that's where we want to be. Unfortunately, this is where a lot of people commit fraud, right? They get married to a US citizen thinking that it's going to be a faster way. We definitely don't recommend that. If we can do it legally, we will. If we have to commit fraud, we definitely don't want to go there. But that's sort of the difference, right? If you're in the F category, you're going to be waiting a long time. And if you're in the IR category, the wait is not long at all. Now we can go ahead to the next slide. Okay. Now, again, the first step is I have a petition through a family member, and now it's my turn. Now there's a visa available. If F4 petition through a sibling, I've waited my 25 years. If I married a US citizen or my child is a US citizen over the age of 21, filed a petition. I have a visa available today. Now, the second question is, how do I immigrate, right? The first question is who can immigrate? The second question is how. And this is what we call the process of residency. If you're in the United States, more likely than not, you want to be able to immigrate within the United States, right? You don't want to have to leave to your country of origin to become a resident when you've been in the United States for 10, 15, 20 years, maybe without status. Now, not everybody can immigrate in the United States, unfortunately. There are, generally speaking, 3 or 4 different ways that somebody can immigrate in the United States. The very first one is what we call an inspection and admission. And this is where somebody came in through the port of entry, right? So like here in San Diego, we have San Isidro down the street. Somebody came in through the port of entry in San Isidro. Usually, maybe they showed a visa or some sort of document, and they were allowed to enter the United States. Now, the inspection with admission just means that procedurally, you used a visa that allowed you to enter the United States, and the officer did, in fact, allow you to enter. But what happens, let's say 20 years ago, somebody shows up to the port of entry, 3 o'clock in the morning, goes up to the officer, doesn't have any documents, right? Never has been in the United States, so they don't even know what kind of documents to present. And the officer, is really tired, really maybe is not paying attention. And they say, go ahead, pásale, right? That's what's called a wave through. Now, today, wave throughs don't happen. Before September 11, 2001, wave throughs were incredibly common. Back in the day, people would just be, go ahead, come right in. Sometimes they would show documents, sometimes they would not. A wave through is an actual inspection and admission, okay? This is very important because many times my clients would have been waved through at the port of entry, but when I ask them, how did you enter? They say, oh, illegally, right? And they're thinking, well, I didn't come in with papers, so I must have illegally entered. Well, you really didn't have a paper to come in through with, but the officer still allowed you to come in. And that is a valid inspection and admission. Now, there's a whole other question as to how we prove that you actually came in the way you said you did, which is really difficult to prove, but it's not impossible, right? And if that's the truth, that's the truth. But now let me change up the story a little bit. Instead of coming in at 3 o'clock in the morning with no papers, what if you came in with somebody else's papers, right? Let's say your cousin has a visa and he said, you know what, cousin, go ahead, go to the United States. Here's my visa. Or you go to somebody and you bought a visa for, $300 back in the day. And you came up to the port of entry, you showed it to the officer, and the officer looked at the visa and said, come on in. Is that an inspection and admission? And the answer is yes. You were inspected and admitted fraudulently, right? Which means that you may need a waiver, but you were still inspected and admitted. And remember what we're trying to do here. We're trying to figure out how somebody can immigrate without having to leave the country, how somebody can immigrate while staying in the United States, right? So it's very important how you came in, right? So fraudulent admission is one way, and wave through is another way, visa is another way. But it's really important that we're very specific as to how you entered, right? Because what if you came in not with a Mexican visa, a US visa? What if you came in with a US passport, right? Pretending to be a US citizen? That's completely different. A US citizen cannot be admitted in the same way a fraudulent admission is, right? And therefore, if you came into the United States using a US passport, a California driver's license, a birth certificate, anything like that, that is not considered an inspection and an admission. So again, what am I trying to get at? The important thing here is, how did you come in, right? Now, importantly also, it's not how you came in the first time. It's how you came in the last time. And in fact, one of the things that we want to know as attorneys is how you came in every single time you came in and every single time you left. And I'll get to that in a minute. But for right now, I'm just wanting to reiterate how somebody can immigrate in the United States without having to leave. That's the first way, proving that you were inspected and admitted. The second way, something called the 245I. Now, many people come to me and say, you know what, my neighbor immigrated, they didn't have to leave the country, they paid a fine of $1,000. I want to pay that same fine so I don't have to leave the country. Can I do that? Unfortunately, not everybody can. If you have a petition, a family petition, or what's called a labor certification, so your employer filed a labor certification for you, and it was filed before April 30th of 2001, you may be able to adjust status in the United States without having to leave the country. Okay, there's all these rules to 245I. I won't get into them too much right now, but basically what we're looking for there is, has anybody filed a petition for you before April 30th of 2001? Now, many people actually might not have a petition, but their parents do have a petition, right? So for example, my uncle filed a petition for my dad way back when I was like 5 or 6 years old. And, you know, I never knew what happened to that petition, but my dad, I remember him telling us about that petition. And when I was 5 or 6 years old, I obviously was a derivative of that petition. Can I use that petition to adjust status through 245I? The answer is yes. Yes, you can, right? So not only do I want to know if anybody has filed a petition for you, I also want to know, has anybody filed a petition for your parents, right? So mom and dad, where are they? Did they become residents? If so, how, who immigrated them, who filed a petition for them? Was it a labor certification? Was it a family petition, etc.? The third way to be able to adjust status is what's called an inspection with parole or permit. And this is a little bit different, legally speaking, than an inspection with admission with a visa, let's say. But a inspection with a parole or with a permit is a sort of entry that the government says, you know what, we're going to allow you to physically be in the United States or enter the United States, but legally speaking, you have not been allowed to stay in the United States, okay? Now, it's more of a legal difference. For you, it looks exactly the same. Whether you entered with a visa or whether you entered with a parole, it's the exact same thing. You got up to the port of entry, you showed a document, and you were allowed in. I won't get into the difference legally, but it's important to note that these paroles do exist. They're very difficult to get. Not everybody can get them. In order to get them, you have to qualify under a specific category. For example, parole in place for military families. This is a special permit that is given to parents, spouses, and children of U.S. service members, and they are allowed to be paroled while in the United States. That's why it's called a parole in place. They don't actually have to go to the port of entry like San Ysidro and come in. They could just go to the immigration offices and be paroled into the United States. Other categories include TPS, temporary protected status, for certain El Salvadorians, for certain Hondurans, Haitians, etc. And they can request a parole to travel back to their country, or any country actually, to go outside the United States. And then once they are allowed to return to the United States, they are paroled into the US. Now they have been inspected and paroled. So that's usually the second type, TPS. Back in the day, many people will remember amnesty. 1986, the old amnesty under the Reagan administration. They were allowed to have paroles as well. DACA is allows for humanitarian parole as well. The Trump administration canceled that since 2017, and we're barely a couple months ago, we're starting to apply again for advanced paroles for DACA recipients. So DACA will have an advanced parole as well, right? So that's usually the third way. And then the fourth way that somebody can immigrate in the United States without having to leave the country is usually humanitarian type of applications, such as Violence Against Women Act, where you're the spouse, parent, or child of an abusive U.S. citizen or legal permanent resident, and you have suffered abuse through that person. You can self-petition and not have to leave the country. You can adjust while in the United States. Same thing with U visas. U visas are, again, for people that have been victims of some sort of criminal activity in the United States, who have cooperated with law enforcement, and usually they would be able to adjust status within the United States. So these are, generally speaking, the 3 or 4 different ways that somebody who's in the United States without authorization, without status, can adjust status while in the United States. Okay, so now what happens if I can't immigrate within the United States? Do I have to leave the country? And usually if there's no way of, if there's already a visa available for you, but you don't qualify under one of those 3 or 4 categories that I just mentioned, then we do have to leave the country. Is all hope lost? Absolutely not. I have clients that leave the country all the time and go to the consulate, and they just have to go outside of the country for, a couple of weeks or, maybe a couple of months. Generally speaking, we wouldn't recommend a client leave the country if they have a risk that they're going to be out of the country for 10 years, let's say. I know many people have come up to me and say, I don't want to leave. My neighbor, my friend, my cousin, they went to Juarez, they went to the consulate and they ended up getting stuck outside for 10 years. I don't want that to happen to me. Well, that's why you go to an immigration lawyer, right? That's why you make sure that you review the case. You want to, be upfront with your lawyer. You want to talk about all the, your history, your immigration history, because that's how you're able to analyze the case, whether this person can legitimately leave the country without risk of staying stuck outside the United States, essentially, right? So who's going to do the consular process? Well, consular process is going to be for anybody who entered without inspection, literally, somebody who came in through the deserts or maybe hidden in the trunk of a car or something like that. And they also don't qualify for 245I. Remember, those are the petitions filed prior to April 30th of 2001. Somebody who has to maybe consular process outside the United States, maybe somebody who has had previous immigration violations and is currently deported, or maybe has already left the United States, or they just are outside the United States and have never come into the United States, right? So let's say my mom and my dad are in Mexico and I'm a US citizen because I married a US citizen and she immigrated me. Now I want to file a petition for my parents. They've never been in the United States. They don't have any issues. Can they immigrate in the US? No, they have to go to the consulate of their country, and that's how they do their immigration process. Go ahead, Anai. Now, this is the part where it gets a little tricky. If I have to leave the country, do I need a waiver, what's called a perdón in Spanish? And the answer is yes, most of the time. If you're in the United States without status and you've been here for at least 180 days or 365 days, which is 6 months or a year, you will have either a 3-year bar or a 10-year bar. Most of my clients that have been here for years and years and years will have something called a 10-year bar. Now, is this the same 10-year bar that will keep me out of the country for 10 years? No, not necessarily. If there's a waiver available to me, then I don't have to wait outside the country for 10 years. I can if I want to. And if I don't, I have to get a waiver. That's the difference, right? That's the point. I have 2 options. I either get the waiver and I don't have to wait outside the country for 10 years, or I wait outside for 10 years, right? Now, here's the what's interesting. Not everybody qualifies to apply for a waiver. In order for us, and Anna, you can go on to the next slide. In order for you to qualify for the waiver, you have to file it having what's called a qualifying relative. And this is either a parent or a spouse who's a US citizen or a legal permanent resident. Now, what if my only family is my children, my US citizen children? I came in 25 years ago. I had my US citizen children. My siblings aren't residents or citizens. My parents aren't residents or citizens. My spouse is also undocumented, or I'm a single parent and I don't have a spouse. Then I have this problem where I'm not going to be able to file for a waiver. And this is where the myth comes from that says that US citizen kids can't immigrate their parents. US citizen kids can petition their parents, but US citizen children cannot file the waiver for the parent. So this is where that comes from. Now, what happens, let's say, for example, my father is a resident. He's never filed a petition for me. If he were to file a petition for me right now, it's going to take 20 years for him to immigrate me, right? But I have a US citizen child, and my US citizen child is 22 years old. Can my US citizen child petition me and my father help me with my waiver? The answer is yes, I can definitely do that, right? My father is a qualifying relative for the waiver purposes. My son or daughter is my petitioner for purposes of the petition. So you could definitely do that. And we do that all the time, right? So again, this is showing that that myth that children cannot immigrate their parents is a half truth. It's a half myth. Definitely U.S. citizen children can file a petition. Definitely if I'm able to adjust and I don't need a waiver, U.S. citizen children is good enough. But if I have to leave the country because I've been in the United States more than a year and I don't qualify to adjust, then I need the waiver. Then I'm going to need my qualifying relative. That's where the parents come in, or the spouses. Okay. Great. Now, I didn't get a whole lot of time to talk about other options. I did want to mention, I think I already mentioned it, but VAWA's Violence Against Women Act, unfortunately, it happens in every community, but very specifically in the immigrant community, where an abusive partner sometimes will take advantage of the immigration fear, right? I'm going to deport you. I'm going to take your children away, that type of thing. So, it's incredibly important. And if anybody, if you or anybody that you know is in a abusive relationship, that you let them know that there are solutions. I have had, unfortunately, conversations with people that cannot be on the phone because their partner is next to them. So they tell me, let me call you back some other day, or let me get outside the house so I can talk to you. It is incredibly sad, but like I said, there are solutions. So please, if you or anybody that you know, let them know, reach out to an attorney. There are solutions. There is definitely help in our community. U visas, again, people who have been victims of a criminal act in the US have cooperated with the government or the law enforcement. I know it's scary, right? If you're a victim and you're already fearing that ICE is gonna come get you, and your thought is, if I call the police, they're just gonna deport me. It's very important, if you are the victim of a crime, that you do report it, because that could eventually also help you out for some sort of U visa. Family members of VAWA and U visas also, a lot of questions come around that. Can my spouse, can my children come in with me on a VAWA or a U visa? And depending on the case, yes, many times we can also bring in the family members. Great. So that's affirmative applications, right? So Antonio talked about how to defend yourself if you get caught up with an ICE raid, let's say. And then what I talked about was how to avoid that completely and just look for some sort of affirmative way to become a resident and not have to worry about some sort of deportation or removal. But yeah, so what is the, sort of conclusions is, like I started, right? The best way to defend against a deportation or a removal is to be proactive. Find a solution before you get into trouble. And, it might not even be something that you got into trouble, because you did anything. It could be something so simple as dropping off your kids at school. It could be, driving to work, or anything in between, right? Start your immigration process before we have to defend you in immigration court. We don't want to be there. I don't want to defend my clients. I would much rather get them the residency or citizenship rather than have to go and stop some sort of deportation. And like Antonio mentioned, know your rights. You do have rights in the United States. The government can do whatever they want. I know that we just got out of a government over the last 4 years that has acted with impunity and has violated many of our community's rights, but we still have rights, right? And that is why people like me, people like Antonio are there to defend you and your rights. But if you get stopped, we're not going to be there next to you. If you don't defend your rights, if you do not remain silent, or you allow them to search your person and they find a passport or a birth certificate or something like that, it's really difficult for us to go in there and try to get that excluded. And if you consented to it, right? So definitely know your rights. Be the first person to defend yourself against the government. Great. Antonio, do you have anything else that you want to add?
Nothing, just thank you for having us. We know we just gave you a lot of information in such a short amount of time. So if you guys have any questions, any concerns, please feel free to reach out to us, set up a consult, and we'd be happy to talk to you.
Yes, absolutely. Looking forward to meeting people. I know not personally, not in person, but definitely through some sort of maybe Skype call or a Zoom call, or just a telephonic call, right? So if anybody wants more information, they want to set up an appointment, feel free to call us 619-662-2170, or an email. Our email is hola, HOLA at abogadosunion.com. Also, we can put up our contact information for anybody who may be interested in setting up an appointment. And we look forward to hearing from our community. Thank you so much. Thank you for your time.